Yes, the judge denied the Wayfarer party's motion to compel with respect to the Vanzan deposition, but let me explain to you why it doesn't matter. In my humble opinion, of course. Vanzan filed a response to the motion to compel saying, there's no dispute here. We confirmed that we're going to provide this corporate designee on the topics enumerated. There's no issue here, and they never met and conferred about this specific problem that they had. That problem being with that timeline that my last video discussed. Vanzan came back and said, we objected, and yeah, we objected to the timeline, but the Wayfarer parties didn't actually discuss with us what that timeline should have been. They just jumped to a motion to compel. And the footnote backpedals a little bit. It says that Vanzan objected and stated that the appropriate time period was on or about the time of the filing. I mean, the Wayfarer parties knew what they meant, and here they're backpedaling a little bit about what they meant by that. And they're saying that they didn't refuse to provide someone to talk about something that happened before the filing. This is exactly what Wayfarer wanted to accomplish. They wanted to make sure that everyone knew that those are the grounds that they were going to try to assert in a deposition, and they wanted to get ahead of that. So they wanted to get it before the judge. So the judge was never going to rule on the specific topics. That's not typically what a judge does before a deposition. Usually objections are raised at the deposition, and then a judge could rule on those objections on a motion to compel that's filed after the deposition, in which the Wayfarer parties would say, these guys objected to this, you should compel them to bring their witness back to talk about X. They wanted to get ahead of that. And so in order to get ahead of that, they filed that motion that they probably knew was not going to be granted. And they got this in front of everyone. We all talked about it last night. And now they have the other side putting in writing that they're not refusing to provide a witness to talk about what happened before September 2024. So mission accomplished if I'm Wayfarer. Now the Wayfarer parties have in writing, both on the docket and between emails between John and Kevin, that they are not going to prevent the testimony of that designee before September 2024. There's been a lot of questions about who is a corporate designee. Is that the same thing as the Judd Wallace thing? No. So when a corporation is deposed, because a corporation is not just a person, I mean, it could be a person, but it's a corporation, its employees have to be designated. The company designates someone to become the person most knowledgeable about the topics that the parties are discussing. So in the subpoena, there was a list of topics, and it's the obligation of the company that's being deposed to produce 1, 2, multiple, however many it takes, people, corporate designated people that can testify about those specific topics. So sometimes you have corporate designee or representative 1 and corporate designee number 2 to talk about, split the topics between the two, because let's say one set of the topics has to do with HR related things and another set has to do with compliance related things, and so you'll have different designees for different topics. That's pretty normal, and designating someone is also something that happens in these specific types of depositions. Something interesting that some of you clocked is that in Fritz's declaration, he talks about a conversation that he had with Vanzan's counsel. Remember, Vanzan, this entity that Ryan Reynolds is the CEO of, is represented by separate counsel. And as other people have mentioned, not actually Golden mentioned in one of her earlier videos I saw, that they could be coordinating. That makes sense. So when you have similar interests, even if you're represented by different law firms, there could be coordination. There's sometimes a joint defense agreement that governs that. But that doesn't necessarily mean that everything that you get as one party and your counsel can be shared directly with the other party, especially if there's confidentiality involved and a very onerous protective order, which this case has. So what happened was that there was a call, and Vanzan's attorney said, I'm under the impression that Lively testified about Vanzan and realized the error. Somebody on the call realized the error, potentially, or maybe they misstated, I don't know. But when asked, do you have the transcript of that confidential deposition? They said, we're not answering that. Not no. we're not answering that. That's just sus. I mean, that to me says that there was that level of coordination between Lively's counsel and Vanzan's counsel is much closer than we are aware of. Because if they've seen confidential deposition transcript without going through the process that the protective order requires, which is to de-designate it and allow all the parties to object, yada, 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 and they just handed over the deposition transcript over to them. Now, I'm not saying that happened. There's just speculation based off of how this is represented in Fritz's declaration. That's potentially problematic.